Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to Surviving the Survivor. It is a podcast that promises to bring you the very best guests in all of true crime on trending criminal cases. And this one has been trending since 2022, November 13th to be exact. We are talking about the murder of the 4 University of Idaho students who have not even entered the prime of their lives. And we're going to dig deep into that. For those who are not that familiar with the story, it revolves around Ethan Chapin, Xana Kernodle, Casey Gonzalez, and of course, Madison Mogen, all roommates in this off-campus University of Idaho house. And then the evening of November 12th, which is a Saturday night, they all go out, they all get back to the house, I believe around 2 a.m. And then somewhere between 4 and I believe it's 4:22 a.m., they are said to have been murdered. And Bryan Kohberger is the accused in this case, and his defense has been kind of going haywire with sealed motions, some of which have been unsealed, and we're going to break it all down right now. First best guest, bringing him in right now, 2-time Idaho Reporter of the Year. He reports for the Idaho Statesman. They are the paper of record for this story out of Boise, Idaho, and Fix has been to Moscow. Welcome to you, Fix. Next up, we got Tara Malik. She's always here, defense attorney, former prosecutor. She ran for office. She didn't win, but she ran, and she might run again. And she might be the first female president of the United States. We just don't know. Tara Malik is cruising around Idaho, always doing her legal stuff. And Greg Skordas is guest number 3, but I see he is working to get himself on camera here. So I'm going to hold off on introducing Greg. Greg actually ran for attorney general in the great state of Utah, and he's been following this case really closely, beginning his career as a public defender, and then turning into an amazing criminal defense attorney. So, Fix, got to start with you. You're the man on this story. You're if paper's the paper of record, you're the reporter of record here. You've been following it as closely as anyone. Judge Stephen Hippler, he's kind of a no-nonsense guy, 4th District. He's presiding over this. And he basically, from what I was reading, kind of chewed out both sides, saying stop with all the sealed motions. He wants there to be kind of more of a public bent to what these lawyers are trying to do on both sides. What is the general tenor just a few months out from this trial, which is set to kick off in August?
You went a direction I wasn't expecting. I thought you were going to ask me about Hippler's ruling. The tenor. We're doing a lot of prep here at the Statesman. We're trying to decide how many people we're going to be putting on this. And today we were actually talking with our colleagues at the state newspaper in South Carolina, just trying to get tips from their coverage of the Murdaugh trial. I think we're all sort of bracing for impact in Boise, to be honest with you. I don't think it's, the topic of the day always around the community, but at the same time, I think people clearly have a date circled. And as far as we know, we are anticipating that Judge Hippler will maintain that schedule. He's changed one date thus far, but really trying to hold the defense and the prosecution to the deadlines with a tiny bit of flexibility. But I do anticipate we will have the jury selection starting on July 30th, followed by trial by August 11th.
Yeah, so that's going to be, as expected, a pretty lengthy jury selection process, obviously about 2 weeks. But Fix, I didn't want you to not go ahead with your own thought there. So as it pertains to the motions, sealed and then having to be unsealed, what was Judge Hippler's? It sounds like he kind of dressed them down a little bit, saying you got to have a little bit more transparency. Is that right?
Yeah, there was a court order, but the thing was that was his follow-up to some conversation he had with the attorneys from both sides at a prior hearing, and basically said, look, we're going to follow the letter of the law here. That's kind of the book on him, as far as I understand. Judge Hippler, that is, and he wasn't. He doesn't mince a lot of words, from what I can tell. And when he says something, he really is trying to make the point. And he already told both sides, look, I'm not interested in these stipulated this process of stipulating between the two sides for keeping things sealed, which had become pretty consistent. And he wants to ensure the public has access to what the public has a right to see.
For those who don't know but have been asking, I already have my travel plans set. I'm going out there at least for the first part of this trial, and I'm psyched to meet Tara and Fix in person when I get out there. But CM Kathy here, the defense is really ruthless in my opinion, Tara. I strongly disagree with an autism diagnosis. That's another piece of new information, relatively new. We're trying to catch everybody up here. Just reaching and throwing spaghetti at the wall to see what sticks. So they did come forward saying, hey, our client is on the spectrum. It appears like they are trying to do everything possible to just stir the pot, Tara. I mean, this is their job, but is there a point where it's got to come with evidence to back it up? And going to get into the alternate suspect theory in a few minutes. But I mean, don't they have to have some evidence to back up all these claims?
Let me answer that in a different way. Let me repose what you just posed to me. They don't have to present anything.
Here's Greg, by the way. Hey, Greg.
Oh, great. They don't have to, defense doesn't have to do anything. They could sit there through the entire trial and just put the state to its burden. It's the state's burden to prove beyond a reasonable doubt that Kohberger is guilty of the crimes that he's been accused of and charged with. So do they have to put on evidence? No, they don't. They could just sit there and poke holes the entire time if they wanted to. But if they're going to launch some sort of defense and put on a defense, yes, they would have to back that up with evidence. The name of the game on this one is really the death penalty. And so this newest information that we have regarding the autism diagnoses goes to more the punishment phase than the guilt phase. So the punishment phase, again, we talked about that, right? 2 phases to this trial. The first is going to be whether there's guilt. And then the second phase is going to be whether and what punishment is appropriate here. And that's when we're talking about mitigating and aggravating factors around the death penalty and whether death penalty is appropriate. So the autism information that we have now goes to whether or not death penalty is appropriate when someone has been diagnosed as autistic. And there's some Supreme Court precedent that was cited by the defense in regards to other instances where there are mental health issues where the death penalty was found to be not appropriate. And the Atkins case the defense cited really had to do with a extremely low IQ. I think in that case, the defendant had like a 71 IQ, and ultimately the court determined that death penalty was not appropriate in that case. So that's the angle they're going at.
All right. And Fix just recently wrote an article, which I'm going to get to, about how the preferred method when it comes to the death penalty in the great state of Idaho is going to be the firing squad, which was just used in the Palmetto State in South Carolina, which is where the Alec Murdaugh trial happened, which is what Fix was just talking about earlier. But Greg Scored, it's great to have you as always. Just everyone is kind of given their bird's eye view, so I want to give you a chance. Where the jury selection set to start the very bitter end of July, and it is now mid-March. What's going on behind the scenes with both the state and the defense as we're inching ever so closely to an actual trial taking place?
Yeah, it's pretty feverish from both sides, Joel. The state has the burden. They've got the work to do. They've got to put on their show, and they've got to do a bang-up job because this case got so much publicity, and there are 4 victims. And like you said, we've even shown their pictures here. These are very sympathetic kids. They absolutely were not, culpable at all for their own deaths. This isn't some self-defense.
Greg's audio just cut out. Go ahead, Greg.
I'm sorry. It just behooves the state to not let anything slide. They absolutely have to prevail in this case because the whole country's watching this. It was such a high profile case. The defense, if they have the luxury of at least sitting back and watching and letting the state's case unfold, but they have a tremendous amount of pressure too, having done death penalty cases from both sides, because they have a person's life at stake. And that's about as bad as it gets when you're in the court system.
Yeah, no doubt. His life's on the line, but these lives are lost, so the system's gonna have to play out. Greg, I'm just gonna keep you on mute and I'll unmute you. But so Fix, let's kind of go through like the big ticket items, if you will. And this is one of them right here. I know that you hopped on this story. Now unknown DNA, unsealed in another filing, we find out that there's unknown DNA, and it's a 3-person mixture under, I think, the fingernails of Madison Mogen. The defense is, I assume, obviously going to hop on this, but just from your perspective, I mean, I know you're a reporter, but you're covering it. You're also obviously a human being. But when you heard this, more because we had heard other DNA that we're going to get to, but now you've got it under her fingernails. What was your initial reaction to this new bit of information?
This was a filing actually from the defense. We're in the motions and limine process, so trying to limit or put guardrails around the way that certain evidence is talked about at trial. And the defense wanted to note that there is this 3-person mixture. You would assume that Madison would be one of those 3 people. And they also tested Kaylee Gonsalves, her friend. She was found dead in the bed next to her, and some unknown individual. And so some of this information was presented at the grand jury trial, or the grand jury rather. And they were trying to explain this as actually exculpatory information. So information that would show that Kohberger is not potentially the suspect. That's how the state presented the information. The defense is trying to point out that, in fact, none of this DNA under her fingernail would appear to be Kohberger, but it was phrased a certain way during the grand jury that it was inconclusive. And they want to make sure that they had some independent testing done on the same DNA. And they want to point out that additional testing has shown that it actually excludes Bryan Kohberger from the DNA under her fingernail. Whether or not we've ever find out who the 3rd individual is, not clear, but it may never be relevant at trial based on the filing from the defense.
Oh, that's interesting. So Tara, I think if I understood Kevin right, he's saying it's probably Maddie's, Kaylee's, and then someone else. So, but when I, someone who doesn't know much about anything, when I hear, okay, now she's got 3 different DNA samplings underneath her fingernails, jurors might think the way I do and say, what's going on here? Were there 3 killers? Were there 3 other people? Now, it raises all sorts of questions. So obviously this is going to be a tactic from the defense. Is it a smart one? But again, do they even have to show whose DNA this is? They have to run testing. I mean, what's going to happen when they present this? What's the government's response going to be?
Well, the government is going to have to provide answers. I mean, if this comes in the motion and limine process is exactly what Kevin's talking about. It puts guardrails around what is actually going to be introduced at trial. And you want to do that ahead of time so you're not introducing things that are going to be objected to and, get into the minds of jurors if they're improper in one way or another. But yeah, the defense is going to try and poke holes here in the theory of the case that the state is advancing. The defense may come out and say there was another killer or the evidence was planted, and it's going to be really important for the state to be able to have witnesses and evidence lined up and to explain why that is not probable, that couldn't have happened, that they're sure that this is the person who committed those crimes. So the state has to be really diligent. There's a lot of pressure on the state's shoulders in order to explain the evidence that it is putting on and to take some of those questions out of the minds of jurors.
Kevin, a lot of people are asking, as far as I know, pertaining to the 911 calls and the text messages. We only have transcripts at this point, right? We don't have the actual audio of the 911. Is that right?
So I wondered if this would come up. There is a YouTube content producer who is saying that he has a copy of the audio. He released a show yesterday saying that he was not going to play it, but he was going to walk the audience through it. And over the course of about 2 hours, he talked through not only the redacted transcript that we have, but also the sounds and so forth that he's able to hear through enhanced version. Now, is any of this true? I don't know, but what I can tell you is that we have across the media landscape, including at the Statesman, filed public records request after public records request for this type of thing. I asked for this very early, and we were told it's an ongoing investigation. Now it's a piece of evidence, most likely. And so it will be played at trial, I would imagine. And it's not been publicly released. Just because the redacted 911 call has been unsealed, that does not mean that, as far as I understand, that the call itself would be released. But he spoke about it with such detail that it's hard to believe that he does not have it. But I just don't know the answer to that right now. But as far as a public release, it is not out there, but it may have been leaked. He claimed he filed a public records request of some kind in order to get it. But we're trying to find it if it's out there.
No one scoops my man, Kevin Fix. So I'm going to go with, I'm not 100% sure that is authentic, but we're going to find out. And after I get off of here, I'm going to ask Fix who this person is, because I have no idea. But again, I keep saying this, we're getting a lot of new people in the chat, which I love, because I'd heard that there are a lot of lurkers. But here's one of them, Kristen Vaughn. Finally got a show live. Love SDS Nation. Oh, thank you. I don't know about the last part of that, but appreciate you all being here and joining us. And we got Toronto in the house. Of course, our original story out of Toronto. The person who lived and was from Toronto. That's Dan Markell, of course. Greg Skordas, to you. Besides, okay, thank you. We're going to get to those for sure. Thanks, COE. 911 transcripts are in. Speaking of transcripts, and shout out to the COE holding down the fort back home while I'm in Tucson, Arizona, here for a book festival, speaking at the Holocaust Museum tomorrow. My mother is a childhood Holocaust survivor, and they asked me to speak, which is what I am doing, because I usually do what I am told in most cases. Greg Skordas. So there, besides the DNA under Madison Mogen's fingernails, a couple of weeks prior to that, there was another unsealing, I believe, but I think we knew some of this, that there was also other unknown male blood DNA. One spot is on the handrail between the first and second floors. The other is on a glove found outside the house, which I kind of recall, if it's the same glove, investigators going back a couple of days later and finding this glove out on the front lawn. But Greg, I mean, this is a house where there was 4 college kids who were partying, like most kids in college, with all their friends over. Is it any surprise that we're hearing about all this mysterious DNA? And is Bill Thompson, the prosecutor, is he just going to say exactly what I just said? Hey, this is a fraternity, or not a fraternity house, but a off-campus house that is almost like a fraternity or sorority house where people were coming in and out of all the time. This is expected. Oh,
yeah, I mean, he doesn't have any choice. That's what he's got to do. Because what this does, Joel, is 2 words for the jury, and that is reasonable doubt. All these things that we're talking about, blood, the DNA under the fingernails, and the other things that the defense is making motions in limine on, are designed to create doubt in the minds of the juries, reasonable doubt. Because if the jury gets through this trial, Joel, and they've heard the evidence and they say, you know what, we're pretty sure he did it, but we've just got some doubt, then they have a legal and moral obligation to find him not guilty. So the state's got to button those up, or at least, like you just said, explain them away and say, look, you know, this is a house a lot of people have been. There's no reason you wouldn't have expected, you know, blood here or there, whatever. I mean, people have accidents, whatever. And so, but the jury's going to have to look at the accumulation of the evidence, everything that's put together, and say, based on everything we've heard, can we set aside some of that stuff that's making us a little uncomfortable and still have proof beyond a reasonable doubt overcome?
Kelly Wentworth, Tara, I'll have you address this. I can't believe how long this pretrial period is dragged on. So it happens November 13th, 2022. And I think an arrest is made about 7 weeks later, which isn't so long. But obviously, we've been dealing with all these legal wranglings. Again, this is a death penalty case. So it is sort of expected to have taken as long as it has taken up to this point, right, Tara?
Yeah, there's a lot of information that's being exchanged between the parties too. So there's a lot of, this was a massive investigation. I think the court even recognized it as being a really large investigation, multiple agencies involved, multiple states involved. And so it's going to take time for the parties to get and to process and to exchange the information, to analyze it. And so I'm not surprised that it's taking a long time. I'm a little surprised that, we're into 2025 on it, but, it's a death penalty case. This is like the ultimate worst case scenario type of case. And so both sides are going to be really careful about, crossing all the T's, dotting all the I's as the judge.
Yeah. We're going to get right into another big ticket item here that the defense is trying to, or are going to work to try to get into the trial, which is the fact that the knife sheath was planted, which in my own humble opinion sounds sort of ridiculous. Before we get there though, Fix, you wrote a story, just flesh out, because there are people here who are outside the United States of America who are mortified, by the way, and one of them is Black Widow, the Republic of Ireland, absolutely mortified that not only do we have the death penalty, but we have it by firing squad. Not only do we have it by firing squad, they just killed someone by firing squad in South Carolina. So what that reporting just did, what did you find out? That Idaho prefers this as the method of death over injection?
So the only method of execution in Idaho has been lethal injection for many years. Just last year, we had a failed, some call it botched, attempt to execute a death row prisoner. He's in his 70s, and they were unable to find a vein that was suitable to ensure they could deliver a lethal dose of the chemicals. And so they called it off after poking and prodding him for an hour. And so as a result, the Idaho legislature this year, some fairly conservative lawmakers decided that the solution to that was to move what was a backup method that they passed 2 years ago, the firing squad, and make that the primary. A couple key details here. It doesn't go into effect until July of 2026. And that's in part because the state needs to renovate its existing death chamber in order to accommodate a firing squad. And if they, in the interim, while they do that, they can't perform any executions. And there are two of these older death row inmates who they've had several death warrants over the years. And the prisoner who just survived last year, he's still eligible, of course, but under a federal stay of execution to review whether or not a second attempt on his life would represent cruel and unusual punishment. That is what his capital defense attorneys are arguing. So the law was signed yesterday by our Republican governor, Brad Little. As I said, 2 years prior, he signed a different law that made the firing squad a backup method. But Idaho previously had this as a method for several years, but ended that in 2009. And a firing squad has never been used to execute a prisoner in Idaho.
There you go. Interesting factoid. We're going to get... Go ahead.
One other tiny beat on that I should mention, given the topic of the show. But the family of Kayla Gonsalves has been heavy proponents of this particular law, and also the past one to make the firing squad a backup.
Yeah, they've made it very clear they want to see death in this case, and I can't blame them. If it was my child, I might be feeling exactly the same way. We're going to get into the meat and potatoes, which is the texts and 911 calls, in just a second. But Greg Skordas, to you, someone asked a question earlier in the chat, which is why I circled back on this firing squad. The jury selection process is going to last a long time, maybe even more than 2 weeks. And do they need to ask jurors up front during the voir dire process, hey, what are your thoughts on a firing squad? I mean, if they have someone who is adamantly against it or says it's completely inhumane, do they have to strike that juror? Is that done in the first part here with the voir dire of jury selection?
Kind of yes and no. So the manner of execution isn't relevant, and that's something that won't be asked to the jury. That is the firing squad versus lethal injection. But the jury will be asked if they can follow the law. And the law in the state of Idaho, just as it is in Utah and others, is that there is a death penalty. So if a juror says, I can follow the law, but I will not impose the penalty of death, then they wouldn't be allowed to serve. But the manner of the execution isn't going to be relevant to the jury. There's no reason to talk about that. I know I'm looking at some of your chats here, and some of the people think firing squad is cruel and unusual. I mean, we can all take our sort of angles on different methods of carrying out the death penalty, but that's not for the jury to weigh in on. The jury can weigh in on whether or not they will follow the law if the penalty is death, and if they say I can't, then they may not be able to serve on the jury.
Yeah, that's very interesting, because I do think, when it comes to just the words firing squad, it takes you back to, like, speaking of the Holocaust, takes you back to those kind of days. So I don't know what your potential jurors' reactions will be. Fix, back to you. So the defense, Ann Taylor, and I got to give her credit, because it's like every day you're putting out a story about one thing after another that she's trying to accomplish here. But one of the latest things is the knife sheath. She is saying that the knife sheath was actually planted. Now, she's admitted that the DNA on the knife sheath, which has been proven, is his touch DNA, but wants to argue that it was planted, and the state basically said, show me the money. What are you talking about? Who is it planted by? So tell us about Ann Taylor's filing there. Is that what she was saying, that it was planted? And does she have any scintilla of evidence that this is actually true?
So let's clarify this just a little bit. Certainly there's been several national headlines over the last 2 days on this particular issue. This was actually a state filing, and they are extrapolating from the what continues to be a sealed expert witness list, and saying that the defense has not disclosed any expert witnesses who will be present at trial, who they're trying to have testify, that this is not Bryan Kohberger's DNA. So it seems that they're giving on that issue. Something that I had in my mind before this filing is that at hearings, you've never heard Bryan Kohberger's defense team ever refute that it's his DNA. That doesn't confirm that it is, or that they're going to give on that one, but they have never said it outright in court that it's not. And so what they are, and Ann Taylor alluded to this at a court hearing that was open to the public, live streamed in January. She said, this is the ultimate issue at trial for jurors that will be before jurors, and that is to determine what does a knife sheath at a crime scene mean. They will have to decide, does that absolutely definitively say that he was there if his DNA was on it, or could there be other explanations? And that's sort of that poking holes in the state's case issue, trying to develop reasonable doubt within jurors. So assuming it is his, they had, again, alluded to the fact that perhaps it got there another way. Maybe somebody borrowed a knife or bought a knife that maybe Bryan Kohberger had come into contact with. These are sort of the theories that will apparently be delivered at trial. And it was the state pointing to the fact that this seems to be the theory, the legal theory, that an alternate perpetrator may have planted the knife sheath with Bryan Kohberger's DNA in order to implicate him and not themselves.
And Fix, there's a question here or a comment: the defense cannot test it. Is this true? Is there, and why? Why, if so?
So there was talk about that at a closed hearing, and that transcript was then released and showed a conversation about where the Idaho State Crime Lab was able to test the DNA from, if people who are really into this case know, but it's the button snap of the leather knife sheath. And so the lab clinician mentioned that they had swabbed the ring around rather than the top of the knife sheath, out of concern that if there was a fingerprint on the knife sheath, on that top of that button snap, they couldn't get that, they couldn't lift that after the fact if they tested it for DNA. So that's the location. And then in terms, I think as a result of the test that the state has done, it is not possible for the defense to do their own independent studies of that. But what ultimately the state is saying is, the cheek swab of Bryan Kohberger directly matches, and it seems that the defense is accepting of the science behind that.
Our friends at Courtroom Confidential here, Tara, hosted by Josh Ritter, and the show is run, much like my show, by his wife, Tiff. Is there a reason why the defense is suggesting their arguments for the DNA now instead of waiting for trial? What's behind that, Tara?
Is there a reason why the defense is suggesting that? Well, they're in the pretrial phase right now, and so you have to give up a little bit of something if you're going to be filing and arguing these motions in limine. I don't think that we should be taking what is in the filings as being some indicator that the defense is absolutely going to put on a defense, that they are going to be calling people, and that they are going to be presenting a certain theory affirmatively. I think to Greg's point, this is about creating reasonable doubt. The state has to prove their case beyond a reasonable doubt. But what the parties do have to do right now is they have to show their cards on what they've got, both through discovery, and also they're anticipating a little bit what the other side is going to be and how the other side is going to be presenting their case. In the defense's case, is if the defense presents their case. That's why, Kevin's talking about it was an issue raised by the state where they're speculating as to what the defense may put on if they decide to move forward affirmatively.
Okay. So the prosecution, if I understood this correctly, is basically arguing that the defense's strategy of claiming the DNA was planted, Greg scored, is they're saying that it is absolutely misleading and not supported by evidence. And then you see this comment from IGG Rocks. Does Ann Taylor also think the person who planted the DNA also stole Kohberger's car and Amazon account? Because there is, I guess, an Amazon purchase for a K-bar knife, or at least Googling, but I believe it was an Amazon account related, connected to him. But Greg, I guess my question is there a point, like, does Ann Taylor have to be careful with anything, or can she just say whatever she wants without anything? And I sort of asked Tara this earlier. Is there like a point where there are like diminishing returns where she's hurting herself, by saying, yeah, it's his DNA, but it was planted. Yeah, but he's not the killer because there's 3 other people's DNA, and there's DNA on the. I get what is the line between being a great criminal defense attorney and making crap up to try to get your client off, for lack of a better way to say it.
Yeah, it's a great question. The line becomes when you start offending the jury, when the jury starts going, wait a minute, we don't believe you anymore. And if the jury decides that she's gone far afield on one issue, they're going to turn her off on others as well. If she's effective and she's creating doubt and she's continuing to do that through these motions, through the various holes that she's poking in the state's case, she's going to get the jury's attention and they're going to think she's doing something right. But if she runs far afield and loses their trust, then she's done something that is going to be very, very hard to recover from.
Yeah, and Greg, she has publicly said that the knife sheath is the single most crucial, critical piece of evidence. Do you agree with her?
Not at all. I think it's important, but there's a lot more to this case. And, it's such a case that is so circumstantial that there is no single silver bullet. It's a case that the state's going to have to put together. Sometimes we say like a puzzle, and I hate to use that, but that's what we say. There's no piece is less or more important than the other. So, that certainly has some relevance in terms of the DNA, in terms of other things, but the jury's going to have to look at everything, every single piece of evidence, and say, do we have enough here to say we don't have any reasonable doubt as to what happened, or do we have some doubt and we have to find him not guilty?
COE, if you want to help me and start to bring up some of these text messages. So between 4 a.m. Fix and 4:25 a.m. November 13th, we're now getting some transcripts of text messages between DM and BF. They're between 4:22, look at this, 4:22:08 and 4:24:27 a.m. to be precise. The second floor roommate is apparently awakened by noises, initially thinking it is Kaylee playing with her dog. And you see this. I know the names, but I'm not going to say them, even though they're out there publicly. And you see the exchange. No one is answering. I'm really confused right now. Then DM texts Kaylee, literally saying, Kaylee, what's going on? I'll hold it right there. This is going to be, I think, critical information as well for the jurors, but you get the sense that there was actual confusion and sort of panic here. Is that how you saw it when you reported on it?
Yeah, I mean, having read this and incorporated into a story with my colleague Alex Brzee, I can't read this and even do my job without feeling that this is quite chilling. And it's because we ultimately know the result. And you have to put yourself in the shoes of these unfortunate survivors who went through this. They appear very confused, and they were obviously out, probably drinking, late at night. It's 4:22 in the morning, and they're hearing noises in a house that is known for parties. And Steve Gonsalves, the father of Kaylee Gonsalves, has said that, they were pranksters, the roommates, and often up late and messing around. And so on your typical, Saturday into Sunday, especially a football game night, who knows what could be happening. And so I'm sure they were very confused, especially, the probable cause affidavit identifies that this same roommate thought she heard crying coming from Xana's room at a point. And if you're disoriented and it's 4:22 in the morning and you're tired, I'm sure it is very confusing.
Who you with is asking. It wasn't Kaylee with the DNA under the fingernails. It was Madison Mogen, who she was found dead next to. But this is a good question. We're getting back to the text in a sec. But Tara, why didn't prosecutors test male blood found? Do we know that they didn't? I mean, we're talking about this mysterious male blood DNA. If you tested it and found out it was, let's just say, Ethan Chapin, who's one of the deceased, that would clear up a lot of things. So do we know for sure that they have not tested it?
I don't think so. I'd have to defer to Kevin on this one. I think he's more intimately familiar with those details than I am.
Kevin, do we know?
So back in August of 23, this DNA, although we didn't know it was blood at the time, Bill Thompson, the prosecutor, said that it wasn't eligible to be submitted to the national database that the FBI houses, CODIS. It didn't meet the criteria. And I'm a bit of a layman on this issue, and maybe our other guests can speak to it. But my understanding is you're not allowed to submit unknown DNA to that database unless you have a strong belief that it was the perpetrator. And they did submit the knife sheath DNA, but didn't get a match because that individual had never been either arrested or convicted of a felony before. And by submitting the other blood DNA, they would then be removing the other DNA they already submitted. So that's my understanding on, in terms of testing. But the lead detective from Moscow PD testified that their lead piece of evidence was the knife sheath. And so they pursued that first. And as a result, they got where they are today. But it doesn't make the other DNA, especially blood, irrelevant, but it made it less of a focus during the initial days and weeks of the investigation.
Yeah. Young Black economist here. Why is it not a standard to test all blood and DNA? It's just another example of what's bad with investigations. Basic stuff is not standardized, in my honest opinion. Greg Score, does you care to weigh in on that before we get back to the texts?
Yeah, I would say this, Joel. In light of what we see on TV with all the testing and the crime labs and the fact that DNA is so not easy, but it's a lot easier to test and compare than it was, say, 10, 20 years ago. It behooves the state to test everything they can and to at least try to test everything they can. I mean, there's almost no excuse given CSI and other things that we know not to test something. And the defense is going to jump all over that. Maybe it was compromised. Maybe there was something about it that the crime lab couldn't test, or maybe there was some other reason that it's hard for me to fathom a reason not to test blood, just to be real honest with you. So there must have been something about it that they were just said, look, we can't test that.
Aaron Hack here says Payne said that they could not put it in CODIS because it would override the other one or something. I'm not sure. Kev, do you know anything about that? About it overriding another form of DNA or another sample of DNA?
Right. So I was referencing that. If you, again, this is my understanding. I'm no expert on this, but they already submitted the knife sheath DNA to CODIS, and if they were to submit other DNA, it would then, I don't know, for the case or what have you, the knife sheath DNA would not remain in the database. Is my understanding.
Okay. Well, maybe we'll try to get a DNA expert on to explain all this through, forensic testing. But there are a lot of people who listen and do not watch this. So I'm going to go back to the text messages. Going to read them through here. So these are mainly DM to BF. And she says, no one is answering. I'm really confused right now. And then they text Kaylee. Kaylee, what's going on? Obviously, no answer. Yeah, dude, what the F? Xana was wearing all black. I'm freaking out right now. No, it's like ski mask almost. Shut the you-know-what. Actually, like he had something over. They're talking about whoever this person is, presumed to be Bryan Kohberger, or at least by the state. Like he had something over is for his head and little mouth. I am not kidding. I'm so freaked out. So am I. My phone is going to die. F. Come to my room, run down here. Tara, you're still young, but you were once a young college student. This is, and I'm the dad of two girls who will eventually be college students, I hope and think. Well, I don't really want them to go to college, but no, I do. But anyway, Tara, this shows like some real panic, some real confusion. How important is this exchange right here? And this is, I don't think everything, but how important is this exchange to show jurors during the trial for the government here?
I mean, I think that this text exchange corroborates what the other testimony may be that's put on by the state. They're corroborating what we've kind of heard and seen in some of these affidavits that have been released, that there was someone who had a ski mask on, that, it had freaked the other roommates out. It corroborates some of the timelines that we're talking about here, which in turn corroborates the witness, recollection. So it is important. I think it corroborates parts of the state's theory of the case. It lends credibility to the witness testimony because you've got some text exchanges that are happening. So when these witnesses are going up and testifying, I mean, the testimony we think would be consistent with, the timeline it set out in those text message exchanges and some of their observations too.
And Greg, we have the state's argument on some of these messages here, and there's another exchange provided. Please answer. DM to Kaylee. DM to Madison Mogen, are you up? DM to Gonzalez, are you up? Like the urgency is getting more and more. The state here in their filing writes, these text messages are not hearsay because it will not be introduced for the truth of the matter asserted. Even if deemed hearsay, they are allowable as present sense impressions as they reflect the consistency and continuation of DM's text messages from the night prior. What does that really mean in English, Greg?
You're taking Tara and I back to law school. We don't like hearsay. We want firsthand information. But sometimes hearsay is admissible under certain circumstances. And one is that you're really not offering it for the truth, because the truth is for the jury to decide, and we want live testimony to tell us the truth. Sometimes it's just for what people were thinking, their state of mind, something like that. So there are exceptions to it, and the court can weigh that and decide, do we want to let it in? Because it's not that harmful for either side, and it's not the kind of thing that a person would just make up. It's not the kind of thing that it would necessarily go to their credibility. So, there are a lot of exceptions to the hearsay rule. They almost swamp the rule itself. And it behooves both sides to sort of look into that closely and say, do we let this in? Is there a way to keep it out? That's how the rules of evidence work.
And you see this question, Tara, for you from Annie K, friend of the show. Does the panel think that the defense constant motions are to mitigate the sentence versus not guilty? Good point. Maybe lessen the blow. Is that possibly what's happening?
I think that they're trying to do anything and everything in their power to, number one, take the death penalty off the table as a possible punishment, and number two, I think to exclude and or, we saw it previously with their motions to suppress certain evidence from being introduced. So to limit what the state can introduce in their case in chief. So both. The answer to the question is both.
Yeah, and you see here that Bryan Kohberger's requests that presentation of DNA analysis from the fingernail clippings taken from Maddy Mogen be limited during trial. That, of course, is the DNA that we were just talking about that was found underneath. But so Fix, it's not just the text messages. We're also learning or know that later that morning, again, they go out Saturday night, which is the 12th, and then they come home, I believe, around 2 a.m. They all return home. And then this happened sometime, I want to say between, like, you tell me the numbers, but 4 and 4:22 or something like that, or 4:25. But it's not just the texting. They tried calling. What did you find out about that?
Just what's in the filing, but that the second floor roommate did call each of the four, including, I was going to say roommates, but Ethan did not live there. He stayed over for the night with his girlfriend, Xana, and no one answered. And there's a text message reflecting that between the second floor roommate and the first floor roommate, who both survived.
Greg, back to you. And Tara kind of talked about this in this text exchange. I'm going to put it back up here. You see, where'd it go here? Right here. It's like a ski mask, something over his head and mouth. And then I'm looking for, is the bushy eyebrows in here? It's somewhere in here, I think. But anyway, they make mention of the bushy eyebrows, and it doesn't take a rocket scientist to realize, or forensic expert, that Bryan Kohberger has those bushy eyebrows. Is that, I mean, how problematic is that? I mean, it's sort of a descriptor that's being corroborated now in the middle of all this chaos. I assume that's got to help the government.
Absolutely. And it's something the defense is wanting to keep out for the same reason we talked about a minute ago, which is hearsay, an out-of-court statement, and it's offered for the truth of the matter asserted, which is that the assailant had bushy eyebrows. So that might be something the judge will take a very close look at. On the other hand, it's not the kind of thing a person would just make up on the fly. So the judge might say it's a spontaneous utterance or an excited statement or something like that, and let it in. Those are things that both sides are going to argue, and those are things that the Idaho Supreme Court's going to look at 5 years from now and say, should the judge have let it in, or did the judge make a mistake? So, I mean, we have to weigh all these evidentiary questions as they come up. That's why we're doing motions in limine, so that we're not doing all that on the fly during the trial. We can sort it out, give the judge a chance to read the law, understand the rules, and try to make the right decisions.
Yeah, and Greg, I think I know the answer to this, but I imagine a guy like Judge Hippler realizes the magnitude of this case. So he's got to be, I mean, I assume he's being extra careful, extra cautious with every ruling he has, knowing that this is going to ultimately get appealed, particularly if death is what's given or granted to Bryan Kohberger ultimately, correct?
Yeah, I mean, nobody wants to try this case again in 5 years or 10 years. And nobody wants to be the judge who caused the case to have to be retried in 5 or 10 years. You want to be careful with the ruling. I mean, the prosecution and the defense have to do their jobs too, so that they don't do something that brings them to the table, an ineffective claim against the defense counsel or prosecutorial misconduct. So everybody's on the line here, and nobody wants to be the reason why this case gets tried again, because that's unfair to the families, it's unfair to the community, and it's frankly unfair to the defendant. I mean, let's just do this right the first time. And it seems to me that the people in Idaho, the authorities, the team that's doing this case, prosecution, defense, and judge, are trying to make sure they do it right the first time.
Yeah, and I hope they do get it right the first time. Tara, to you from Sunshine, Well, everyone that was texted and in the house, it's these two surviving roommates. I mean, they're both going to be called as witnesses. I know one of them was having a really difficult time. I cannot imagine the survivor's guilt and the, just the sadness, the sorrow, all those emotions combined to have to get up there and be a witness now in this trial. How do you approach this if you're both the government and the defense here? How do you approach these two witnesses?
Sensitively. I mean, really, it is so delicate. We have to remember how young these folks are. They've went through some an incredibly traumatic experience. I think that the state is going to have to, really prep their witnesses, and especially these folks, because of their age, because of, these other variables, like, they were drinking, and that may have affected their perception or their recollection. And those are all issues that are going to be brought up on cross-examination by Ann Taylor and her team. I think if you're the defense in this situation, you have to do the same thing. I mean, it's a really fine line between aggressively advocating for your client and then turning off jurors because you come off sounding like a jerk and you come off sounding like you're just harassing these witnesses to harass them. So I think the defense is going to have a tricky job as well. There's no issue here, or there's no question here that a heinous crime was committed. The question is who committed the crime. And so the defense is going to have to be gentle to that, right? Acknowledge in some way that they experienced a traumatic event and say, but it wasn't, are you really sure you saw what you saw? Is it really my client that did this?
I always say best guess, better community. This is why Chelsea Whitaker follows this particular case and others, but this one very closely. Bushy eyebrows are not mentioned until several days later after Dylan, the roommate, had been interviewed multiple times. No bushy eyebrows in the text messages, no bushy eyebrows in the 911 call transcript. It's weird because I almost thought that I had read it, and that's why I went back to it. But Fix, apologies if we just in terms of the calls. What do we know? And I don't mean the 911 call yet. Apparently, one of the roommates tries to call all four of the roommates, but gets no response. Like, does that person call individually all four, or just try to reach out to the four by making a single call?
No, I believe there are four separate phone calls, and obviously based on the timeline, we understand none of them answered, and we know why.
And then the roommate sends additional text to both Kaylee and Mogen at 10:23 a.m. What's obviously very sad and interesting about this is they have been presumed to be dead for, 5-6 hours at that point, right? Or 5 hours, if I'm doing the math right. Yeah,
you have that right. But I think, we have to give the benefit of the doubt to the second floor roommate who was sending the messages that, she didn't know that. And so just trying to understand what happened, particularly if you're coming out of, a fog or sleep or the trauma of the situation.
100%. And Greg, on that point that Fix makes, what does the government have to do here? Because look, these two roommates, it's sad, but this always happens. They've basically been vilified to some extent in the media. And there's probably going to be jurors who are going to ask the same question. They're going to say, why did they wait so long? Is the government going to have to bring an expert on to say that because of trauma, because of the situation, because of the chaotic nature of all this, it's perfectly reasonable and normal that they didn't make this 911 call till hours later? Are they going to have to give a roadmap as to why this was the case?
I don't think that's necessarily expert testimony, Joel. I think it's common sense, and you articulated it as well as I think the prosecutor will, which is to say nobody really knew what was going on. There was so much chaos and it's the nighttime, and it's a college town, and it's a house where there's probably has been some chaos in the past. So I think people just didn't know how to react. And I think the jurors will understand that. I don't think that an expert can come in and clear that up any better than our own common sense, having been, awakened or disturbed or, in a house with a number of people, how we would have reacted. And I think the jurors will say, well, that I think I probably would have done the same thing. And if that's the case, then there's no harm, no foul.
That makes sense to me, and they'll save money on an expert witness there. But Fix, back to the autism diagnosis. Can you just flesh that out a little bit more? So, like, where did they get this from? Is this from a medical doctor? Why had Bryan Kohberger, to the best of your knowledge, never been diagnosed as being on the autism spectrum prior to this?
We actually don't know that, but what the defense did was bring in a doctor, I believe a psychologist out of New Hampshire, who spent some time with him and built a report about some of his mannerisms and, to the extent that he is on the spectrum. And this is, as Tara was speaking about, another effort to alleviate them of a potential sentence of death. Idaho famously doesn't have an insanity plea. And she also spoke about the U.S. Supreme Court precedent in terms of what would mitigate a potential death sentence as a result of, low IQ or a mental health issue. But it's important to note that this is a neurological deficiency, a disability. And so will it hold water in terms of this particular judge striking the death penalty? I guess that remains to be seen, but and maybe our two attorneys can speak to this, but something that surprised me about this was this came late. The defense had already had deadlines and oral arguments, in fact, about the different attempts to strike the death penalty, everything from evolving standards of decency in the United States to, unconstitutionality generally, and even against international law. And we went through that 2-3 months ago, and Judge Hippler did not accept any of them. So for me as a reporter on this case, I was surprised to see yet another effort past the deadline that Judge Hippler had previously set.
Look at this, Gia and TJ. Mom, Joel, I really hope you go for this trial because we need the good information. I'm going to be there. I don't know about the entire trial because it's going to probably last 3 months, and my kids will forget who I am, and my wife will definitely forget who I am. So I'll be there for as much of it as I can, but we're going to be covering it for sure, gavel to gavel. Scortis, are you going to be going out there for your Utah TV stations?
I haven't been asked yet, Joel. I did go up there, as you recall, for the what's her name? Lori Vallow and Chad Daybell. I watched those two trials, and they weren't the same location. I think they're going to try this case in Boise, I think, aren't they, Tara? And if that's the case, I may go up there and cover that. I watched openings and some of the closing arguments and a little bit during those trials. It was really interesting. And I think this one would be interesting as well. So I hope I do get to.
Yeah. Shout out to my good friend, Matt Brode, who's in the chat, kind of poking fun at me. He lives here. He is the chief meteorologist for the NBC station in Tucson, Arizona, and warned me that the rain and the wind would be devastating today. And if I could show you out my window, there's not a cloud in the sky, and it's a beautiful day here in Tucson. So weathermen and women have one job, to get the weather right. And sometimes, like 97% of the time, they don't. But he still is a fantastic weatherman. So, and I also lugged out heavy jackets because he told me it was going to be like 20 degrees and it's 79. So there you go for the sign. That's why I always tell people, don't watch the weather on local news. Just open your shade and look out. That's all you got to do. That's my advice on weather. A couple quick things. I promise Fix, we're getting him out of here because he's got to go break more news. And I cannot afford Scortis and Tara Malik's billable hours. So the final thing I kind of want to discuss is just the alibi. So Fix, to you first on this, the alibi and legal proceedings. They stated originally, Kohberger's legal team, that he's out driving alone the night of the murders around 30 miles southwest of Moscow, Idaho. But now the state is saying, hey, if you use this alibi, which they're basically making fun of, you got to put your defendant up on the stand to explain his whereabouts. Is that right?
Yeah, they have no corroborating witness, and I'm not an attorney like our other two here, so they could probably speak better to it. But there are requirements in Idaho criminal rules as far as how you can legitimize your alibi claim, and part of Idaho rules are that you have to actually issue these filings ahead of time in order to justify it. Otherwise, a judge will restrict you and say you can't use that argument. The prior judge, whose name is Judge, now retired, but he had previously called this an alibi, so-called alibi, and acknowledged that it was problematic what their filing was. Bill Thompson also noted, basically, thank you very much during a pretrial hearing, saying, yeah, we already knew that he was out and about. So thank you for confirming that. But if they're going to claim that Bryan Kohberger, who liked to go stargaze and moongaze and so forth, was out and about that night, he's going to have to take the stand in order to make that argument. Is the position of the state. A ruling is yet to come.
You see here, thank you, Fix, from CM, from Kathy, may justice be served for these 4 innocent college students and their loved ones. I've kept the photo up because the only person we seem to see these days is Bryan Kohberger's mug, and it's really about these 4. We're going to get closing comments in a sec, but Tara, a question came up again, which comes up often, which is, why does Bryan Kohberger get to sit in a courtroom in a suit and tie? I mean, there are no jurors in there right now, but a lot of times you'll see them in the jail jumpsuit. How come not Bryan Kohberger?
That is a really good question. And I think it was Gene Fisher, who's been on your show before, who'd remarked how unusual that is. And that's in my experience too. It's unusual to see that, pre-trial that they're going to be in suits. One reason could be that there's so much publicity around this case. And there's photographs that have been taken in the courtroom, and those are being disseminated and out in the public, and seeing somebody in an orange jumpsuit, could infer that they are guilty before they've gone through to trial. And so seeing somebody in a suit could, have an effect on a potential juror walking into that courtroom and being able to keep an open mind, innocent until proven guilty. So, but it is unusual.
Well said. For those who do not know, now you know. Tara Malik, smart legal mind. She does defense work in the entire state of Idaho, based out of Boise. And when I come out there, we're going to lean on her, Fix, and Greg on this case, as well as others. But I'll definitely be picking Fix's brain day in, day out, because he's been following this step by step the entire way. So Tara, just very quickly, your final thoughts. And just in regards to this alibi issue, is there a chance? Do you think there's a chance? It'd be fascinating to see Bryan Kohberger take the stand. We all know he was getting a PhD in criminology. A lot of people think he thought he was going to outsmart everyone, if in fact he is the one who committed this. Do we see him up there? Or do we see him up there for another reason? Because he begs his defense team to say, let me tell these people why I'm innocent.
Boy, I'm no psychologist. So, I mean, there's always a chance that he goes up and testifies. Is it advisable? Not necessarily. The alibi or non-alibi, as it's been referred to in different cases, is, to me, problematic. I mean, I've said it before and I stand by it. It's corroborating part of the state's theory of the case, which is that he was not at home, he was out. And so I think that's why Bill Thompson, during one of the pretrial hearings, had basically said, something along the lines of, yeah, we knew that, when the defense started arguing about it. So, I don't see it as being particularly helpful, that type of alibi, but to be seen, I guess, how and what the defense does with this.
Thank you. Greg Skordas, he once ran for Attorney General of the great state of Utah, where there's a lot of bizarre crimes going on as of late. Greg's also a public defender. That's how he started, and is now a very successful, savvy, and smart criminal defense attorney. Greg, to you, is there any chance that this trial doesn't move forward, that Ann Taylor says, all right, let's just give this guy life in prison. Bryan Kohberger says yes, and there's a deal made, or is this 1,000% headed to a jury in the next couple of months, or more than a couple?
Nothing's 1,000%. I would say this, that for the state to walk away from the death penalty would really require the consent of 4 victims' families. And I don't know that they're going to get that. The defense to convince their client to spend the rest of his life in prison without the possibility of parole is another hard sell. So 1,000%, no way, maybe 95%. I mean, these cases resolve in the criminal justice system, Joel. 95% of cases resolve before trial, but we don't have the stakes like we do in this case. And so when the stakes are this high for both sides, it makes it much less likely that it'll resolve, but it very well could. It very well could.
What I like to read are comments that people don't think I'm going to read. That's a dumb idea, Joel. He was such a good planner that he used his own car and pulled right up to the front door to getting a PhD so I can learn to crime is another dumb idea. I'm not the smartest guy alive, but these are some of the things out there. But there are there are a lot of people who are buying into some sort of alternate theory that he's not the guy. I'm not going to ask you about that because you're an objective. Let me ask Scortis about that. I mean, Scortis, what about this? There's all these alternate theories out there that it's not him. There's a movement basically saying that it's a conspiracy here. We get that all the time. How, if at all, does this ultimately impact jurors or the way this case moves forward?
Well, the conspiracy theory part doesn't help at all. I mean, the jurors don't really buy into that. But the alternate theory, again, and we've talked about this, Tara and I especially, if you've got some doubt in the jury's mind that something's going on or that it could be another person, that's critical to the defense in a case like this. But to say that it was some plant or some conspiracy, that's going to be a very, very hard sell for a jury, because who would do that? I mean, frankly, that's just not a logical, that doesn't even make sense.
One of the things that I thank you, Greg, I love about the show, it is one big happy family. I say best guest, better community. And I've acquired a lot of new wives/mothers. Joel B. Nice, young black economist, is cool. I was super nice to her. I know I should see her in the chat all the time. I'm just saying that she has, I believe, believes that there's someone else responsible. We're all entitled to our opinions. Ned, I wasn't mean, Ned. Just because I say you have a bun with a sewing needle in there, doesn't have to. You don't have to come at me now. Fix is the reporter of record on this story for the Idaho Statesman, 2-time Idaho Reporter of the Year, not once but twice. Not a lot of people could say that. I know March 24th is an important date. The defense is going to have to file their responses to the prosecution motions. April 9th, there's oral arguments on motions in limine. Jury selection set to begin July 30th. I guess, what are you anticipating right now? And I'll ask you a question I've asked you before. What's the biggest scoop you could get right now, Fix?
Whenever I appear on your show and others, they always ask that same question. The thing that's challenging now, and I've said this before, but we're all waiting on the same court records. And so we're basically all, drinking from the same fountain. And it's a matter of, having the institutional knowledge and trying to outdo others a competitive national market on the information. But there's really, through the gag order, there's no additional information that's available. So when something like a 911 audio recording either leaks or someone claims to have it, everybody's trying to jump at it. And I know many media organizations are chasing that. But, the motions in limine are, we're learning a lot from those filings, even though the filings themselves are trying to kind of set the ground rules for trial. And so who would have thought we'd be talking about text messages between the roommates and having a redacted version of the 911 call and understanding what may have been under Madison Mogen's fingernails. And yet those are the conversations we're now having, despite them just basically being the tug of war between the defense and the prosecution about what's going to be presented at trial.
Well, listen, thank you to all of you. Maybe this is one of the smarter comments here, not that the others aren't. Pantoufle, I don't know how anyone can be so sure when there's evidence we don't know yet, and we have not seen everything. Annie K reminding me, once again, it is a knitting needle, not a sewing needle. I always screw that up. But thanks to Greg Skordas, thanks to Tara Malik, thanks to Kevin Fixler, the Idaho Statesman. Support local journalism, not the dummies on broadcast news, but the guys who actually do the print report, the real reporting. Support the Idaho Statesman. Go find it. It's worth the subscription. Love you, America. Love you, Utah. Love you, Boise, Idaho. And justice for Ethan, Maddie, Kaylee, and Xana Kernodle. Every time I think about how their lives ended, and it is a tough pill to swallow. We'll see you guys tomorrow, 5 p.m. Eastern time, part 2 of Wendy Adelson's police interview being deconstructed by America's most respected detective, Bill Waters, and retired FBI special agent, who's also an expert in interviewing, and that is Scott Duffy. We'll see you at 5 p.m. Eastern on Friday, live from Tucson.